State ready to proceed?
Good morning, Your Honors. May it please the Court. My name is Whitney Mackey, and I, along with my co-counsel, Angela Hensel, are certified legal interns representing the state of Florida in this case. Your Honors, today we're asking the Court to reverse the trial court's order granting the defendant's motion to suppress his confession. In this case, the defendant was charged with 2 counts of lewd and lascivious battery on a 12-year-old. The police in this case went by the defendant's house upon learning of the incident and asked the defendant to come by the police station for questioning. Immediately upon his arrival to the police station, he was read his Miranda rights. Post-Miranda, the defendant made his confession. The defense then filed a motion to suppress, alleging that based on the defendant's low IQ and hearing impairment, he was unable to give an adequate waiver of his Miranda rights. In support of their motion, the defense presented the findings of a forensic psychologist who testified.
Well, the trial court ruled that the state did not meet its burden in proving that the confession was freely and voluntarily given. Why is that an error? And it sounds like the trial court, weighed evidence and made an evidentiary decision on which had more. And what is the extent of our review of that?
Your Honors, there's actually a 2-part examination that this court should do in reviewing an order on a motion to suppress a confession. And that first is whether there's competent substantial evidence to support the trial court's findings of historical fact. Here there were no findings of fact entered by the trial court. If you look at the order, it grants it and does not find any specific findings of fact. Second, this court should review whether or not the correct legal conclusion was found by the trial court in determining whether a waiver was knowingly, intelligently, and voluntarily given. And that legal conclusion was incorrect as entered by the trial court.
I think we have to assume, right, that the trial court found that there was insufficient evidence of a voluntary confession. I mean, otherwise I don't think we can hold that if a trial court doesn't make findings of fact in a suppression case, we're going to have to reverse. So, I mean, we have to assume there's an implication that he found that, or she found that the evidence did not establish voluntariness, right?
Your Honors, we would respectfully disagree. We would argue that there is no competent substantial evidence that the trial court could have relied upon.
I understand that. That's the second point of the question, but I'm sorry.
No, I'm sorry. Whose burden is it to go forward?
It's the state's original burden to establish beyond a preponderance of the evidence. That's the suppression.
So let's assume the defense never even shows up. They file the motion to suppress. The state has to go forward. The defense either, reads their email or plans their next hearing or whatever. They don't really participate in the hearing. Is the court compelled to accept the state's evidence?
They're not compelled to. It is the trial court's decision whether or not to establish whether they met that burden beyond a preponderance of the evidence. But it's this court's decision to review that ruling and determine whether or not there is sufficient evidence to support their finding. And in this case, there isn't. In this case, the defendant was read his Miranda rights immediately upon arriving. He was read the top portion of the Miranda warning containing the formal warnings, and then he was given the form to read himself, which contained the bottom portion, which was his waiver. And he even signed that waiver acknowledging his understanding of it. On multiple occasions, the defendant was asked if he had any questions or needed clarification on anything at all, and he replied no. On multiple occasions, the defendant even acknowledged that no coercion or intimidation or deception was used during this interrogation.
Well, that would all be competent substantial evidence to support a finding in the state's favor.
Right.
But does that compel a ruling in the state's favor from the trial court?
Your Honor, we would argue that the evidence is all in the state's favor. There is nothing to indicate in the record whatsoever that the defendant did not make a knowing, intelligent, and voluntary waiver.
I think that what these questions are trying to get the focus on is you presented this evidence. A, he signed the Miranda warning form, right?
Yes.
B, he was told on multiple occasions, are you having any problems? Because he mentioned having his wife with him.
Right.
And ask if that was clarified. And, I think if the trial court issues a ruling that the suppression is going to be denied, I think the other side would have a very difficult appeal. But here, he listens to your evidence and says, or she says, I don't think you meet your burden of showing by a preponderance of the evidence that this confession is voluntary. And I think an interesting aspect of this case is, how do we get into that ruling and say, oh, you can't make that ruling? You can't reject that evidence that the state presented.
Your Honor, I think it's because there is no evidence to support that ruling here. There just isn't any there. The defendant acknowledged that he understood it. He was given multiple opportunities to clarify.
But within the transcript of the information the state put forward, even not including Dr. Derrico's testimony, but the state put forward a transcript, and it had Mr. Beck not spelling his name right and being told he could lower his hand after being sworn, and there was some reading of that would seem to indicate he really didn't understand what was going on.
And Your Honor, we would respectfully disagree. The misspelling of his name might go to his literacy, but it certainly doesn't go to whether or not the state made it clear to him what was going on in those proceedings and whether or not he understood the rights as given to him. And you mentioned Dr. Derrico's report. That report was based off of completely separate warnings that were actually administered. Those warnings that he was tested on not understanding were much more complex, with much more complex terms.
Before we get to their evidence, we're still, or at least I'm still interested in focusing on your evidence and the abstract question, if you will, that we face, which is, as a previous question raised, the judge sits there, he listens to your evidence, and it might be the greatest evidence in the world. Judge, he came in there, and here it is on the transcripts, and he's saying, I am voluntarily confessing. I am absolutely voluntarily confessing to this crime. And the judge says, I don't believe it. I reject this testimony. Let's just say that's the hypothetical.
Okay.
Not your case. Let's say your evidence was even better. And he says, I am absolutely voluntarily confessing. And the trial court is sitting there and says, I don't find it credible. I don't find it voluntary. How do we reverse?
Your Honor, you can reverse because it's based off of zero evidence. There is nothing articulable in the record that suggests that he didn't understand.
But now a jury is told in the standard jury instructions, a jury is told in a trial, you can accept, reject any evidence you think you determined to accept or reject. Expert witnesses, any testimony, any credibility by the fact finder, which is the trial court here, can be accepted or rejected. How do we as an appellate court in this case, which to rule in your favor we have to write, how do we as an appellate court say, Judge, you don't have the authority to reject that testimony?
Your Honor, I would just point back to the standard of review. On the standard of review, this court must evaluate whether there's competent, substantial evidence to support the trial court's ruling. And I would just turn you back to the record. There is no competent, substantial evidence to support the fact that the defendant did not understand the very simplified terms.
Well, if the state has the burden of proof, they have to produce competent, substantial evidence.
And we believe that we have.
If the judge says, I don't believe this, there is no evidence, so the state loses. It's Judge Thomas's question.
Well, I'll clarify what I meant. There's no evidence to support the trial court's granting of the motion to suppress. There is evidence to support the fact that the defendant here did understand, and that comes from his repeated acknowledgement that he understood what was going on, and it comes from the fact that he was offered any chance at all to clarify anything he needed clarification on. He never took anyone up on that.
Do we need to reject the doctor's testimony just because he used a different form of Miranda?
Your Honor, yes. That report shows very little probative evidence.
So if there was just a word difference, then we would reject the expert? He can't testify that, look, this guy has a 70 IQ and he can't understand these Miranda warnings.
Your Honors, that expert report was based off of a two-part analysis. The first part he scored a 6 out of 8 on, which was only somewhat below average, and it was based off of completely different warnings. And the terms within that warning were not just different terms. As you say, they were much different terms. They were, rather than interrogation, the word question was used. Rather than consult, the word talk was used. They were much simplified warnings. And, for example, the third warning that the psychologist...
he received much more simplified
He actually received much more simplified
warnings. In the form that
warnings.
The doctor used had words like interrogate rather than talk.
Right. The third warning that the psychologist tested the defendant on was you have the right to consult your attorney before interrogation and have the attorney present during interrogation. When the warning he was actually given was a much simpler, you can talk to your lawyer for advice before we ask you any questions.
All right,
And-
now, the trial court noted, or the record demonstrates that the state attorney in the suppression hearing said, hey, we know this witness, we respect this witness, we've used this witness before. So there's no question here regarding the credibility of the expert witness, right?
The credibility of the expert witness's findings are at issue
I
here.
understand that. So on the findings then, what was the exact statement the expert said? It is highly probable that this defendant did not understand the warnings?
Your Honors, he said there was a possibility that the defendant did not make his waiver with a full understanding.
Didn't he then use the word probable?
He did. He did at some point. He said, and it's probable, excuse me, that his low IQ, which was a borderline IQ of 70, was not in the range of mentally retarded, but a borderline IQ of 70 coupled with interrogation makes it probable that the voluntariness of his confession is called into question. And then I'd like to point your attention to the fact that during the motion to suppress hearing, the prosecutor specifically asked the expert, after conducting all those examinations and specifically mentioning voluntariness, if he could definitively testify that the confession was in fact involuntary. And the expert replied no, he could not testify.
But I guess that gets back to the interesting aspect of this case in terms of a trial court makes no findings of fact. We have to assume, do we not, that the trial court accepted the expert witness's testimony, that it was probable, thus defeating your burden of persuasion, i.e., that the confession was voluntary. That's kind of the context of this case, don't you agree?
I do agree to some extent.
I think we can safely assume he accepted the expert witness's testimony.
That was never explicitly
I know,
said.
but I mean...
What was the exact testimony again of the expert?
The testimony said that based off of his findings, it was possible that the defendant did not make his waiver with a full understanding of his rights.
And quite honestly, you could go in and you might not understand the full, correct? I mean,
correct.
The full ramifications of your confession may not be known by anybody. I mean,
but he didn't use the word I'm sorry.
He did use the word probable, yes, and he never definitively testified that this defendant did not understand. And again, he specifically said he could not testify to the fact that this confession was in fact involuntary. Therefore, Your Honors, applying the facts to the law, the trial court ruled incorrectly, and this court should find that there was no competent substantial evidence to support that trial court suppression, given the record and the fact that there was nothing to indicate that this defendant didn't fully understand his rights. And with that, Your Honors, I see that I am in my rebuttal time, so I would like to reserve the remaining portion for my partner. Thank you.
Good morning, Your Honors. May it please the Court. I'm Haley Dewey, and along with M.J. Lord, my co-counsel, we represent Jason Beck. Your Honors, I would like to begin by clarifying the exact words of our expert as to the knowing and intelligent prongs of the waiver. Dr. Derrico testified that Jason Beck probably was unable to fully understand the consequences of waiving his rights. And as to voluntariness, expressly said, I think a lot of the reason why Jason Beck made this statement was the desire that all these individuals, these being mentally deficient individuals, have to appear normal. And factors inherent in the interrogation situation compounded by the defendant's low native intelligence may throw the voluntariness into question.
Wouldn't it be true that virtually anyone who confesses is showing a lack of a full understanding of what they're doing? I mean, why would they ever confess? Most defendants. If it's not to achieve some kind of perceived sense of, maybe they'll be nicer to me, or, but clearly they are not appreciating the full consequences of their confession, or they wouldn't confess. Isn't that a reasonable, in other words, isn't the doctor just testifying to a truism?
I would disagree with that idea, although I think it is reasonable. The Supreme Court has spoken to the voice of God, compelling people to speak and confess completely, legitimately, knowingly, and intelligently comprehending their rights and voluntarily making a waiver of those rights. But in this case, Jason Beck has several factors and several pieces of competent, substantial evidence indicating that not only did he not voluntarily waive his rights, but that he did not knowingly or intelligently waive those rights, meaning that he neither completely understood the nature of those rights and that he did not understand the consequences of waiving those.
But he was asked, Do you, I think the exact Q&A was something along the lines of, hey, we've talked to you before, and then you mentioned having your wife here, but we want to clarify, is it your desire to talk to us? And he says, talk, right?
That's exactly right, Judge Thomas, and I actually think that colloquy in itself is quite telling because we're dealing with the defendant here who not only has the low native intelligence, but also has a congenital hearing defect. He also, according to the forensic psychologist, which was not controverted in any way as to his credibility, has issues wanting to appear normal. So the simplicity of my client's reply in that context, which the actual...
Did he testify that this defendant wanted to appear normal? Or you said a couple of things regarding Dr. Derrico's testimony. You said that people with low native intelligence often want to appear normal, or they're often cooperative. And that sounds a little bit kind of like a across the board, anybody between these numbers is incapable of giving a voluntary knowing confession. And that's not what the Supreme Court says the test is, so help me there.
Certainly. The expert does say that these individuals, mentally deficient individuals across the board, have a desire to appear normal, but that's not just a generic surplus opinion. That is specifically regarding Jason Beck, and the state was certainly free at the suppression hearing to challenge the finding as with regard to the desire to appear normal. They failed to do that.
Let me ask you
Sorry, Judge Thomas, I got a quick follow-up on that. Specific to this defendant, Dr. Derrico on cross said that he could not definitively say that the appellee did not voluntarily provide his statements.
That's true. However, the expert said that it may throw the voluntariness into question. However, this inquiry is a totality of circumstances for knowing, intelligent, and voluntary waivers. The state focused exclusively in its brief upon the voluntariness issue. However, the defendant's mental status, combined with some of his linguistic issues, which were found by Dr. Derrico to be substandard in terms of his ability to comprehend all the waivers, is also relevant to the knowing and intelligent prongs of that waiver. So while, of course, Judge Roberts, you're correct that our expert could not definitively say that this was not a voluntarily given statement, he did say that the voluntariness is thrown into question and the knowing and intelligence prongs were probably not fully satisfied.
I did have a question. I'm going to ask you the same hypothetical that I asked your opposing counsel. Let's say the defendant sits there, different defendant, average intelligence, sits there and says, I just want to make the record crystal clear. I am knowingly, intelligently, and voluntarily confessing to this crime for whatever reason. Perhaps, as you mentioned, the U.S. Supreme Court had talked earlier. I think the U.S. Supreme Court used the phrase, confession is good for the soul. He felt the need to confess. I voluntarily confess. The trial court says, motion to suppress granted. How do we treat such a ruling?
In the context where you're asking my co-counsel, how could you reverse the ruling, if I may, I'll
right.
frame it that way.
The state files an appeal because the trial court had nothing before it but a defendant's testimony that he or she knowingly, intelligently, voluntarily confesses. There's none of this evidence such as you have here, and the trial court leans back and says, I'm rejecting any kind of finding that this was knowing, intelligent, and voluntary, essentially saying, I don't believe the defendant's own words, and I'm going to grant the motion to suppress. Do we have to affirm?
Well, not necessarily, Your Honor. Actually, the second DCA in the Benitez v. State case they reversed the trial court's decision because the appellate court felt that the trial court did not use the correct legal standard, that is the totality of circumstances specifically standard. And because that, with other factors in the totality of circumstances, persuaded the appellate court that the ruling should be reversed. That case is readily distinguishable from this case because our order, while very scant on factual findings, in fact there are no express factual findings in our order granting the motion to suppress, says based on the totality of circumstances standard. So that's why the Benitez case is distinguishable from this case. And that is my answer to your question.
So a trial judge would never be reversed on a suppression order if the judge wrote, based on the totality of the circumstances,
That's not
the
necessarily.
motion to suppress is granted.
That's not necessarily true, Judge Hawks. A couple of cases, for example, McIntosh v. State, has been reversed because the court felt that the weight of the evidence, for example, in that particular case, the court was privy to a videotaped transcript of the hearing, the
Well, let me
suppression
share with
hearing.
you my real concern.
Sure.
Basically, it kind of appears to me that we have an individual with a 70 IQ, that the trial judge just doesn't think people with 70 IQ should be confessing. When everything else about the case certainly shows that it would meet the standard. The Supreme Court has told us that a 65 IQ is not, in other words, we can't draw these lines. It might be easier if we drew them, but we can't draw them. And it just kind of seems to me that the judge drew that line. There was even your expert's testimony was, well, maybe he didn't understand, and I would concede that's probably true. And I would even go further and say I'm sure he didn't understand the full impact. I'm convinced of that. So are we compelled to follow just because he said he considered the totality of the circumstances?
I would say yes, but to...
Did he say that? Or maybe I got the
Pardon
wrong
me?
order. It said this
Did the order say?
It said this matter came before the court on the defendant's motion to suppress. After having considered said motion, evidence, and argument of counsel, and being otherwise fully advised, the court finds as follows. The state failed to meet its burden to show by preponderance of evidence that there was a knowing, intelligent, voluntary waiver of rights by the defendant. I don't see where he says having considered the totality of the circumstances in there.
That may be my misstatement in that case, then, Judge Roberts. I'll be happy to look at that and supplement it. But to address your question, Judge Hawks, with respect to a bright-line rule, you're absolutely correct. With respect to, I would agree that it's certainly not advisable to say that certain defendants, by virtue of their intelligence level, are unable to knowingly, intelligently, and voluntarily waive their rights. And that's why I think the totality of circumstances standard in this case is very helpful, because we have several circumstances, several pieces of competent, substantial evidence showing us, and unrefuted by the state, except as to the instrument used by our defense witness. No other witness was engaged for this. The officers were not brought in to testify as to the specific circumstances.
So let's go over those pieces of evidence.
Certainly.
And just to at least put your mind at ease from my perspective, it looks like the trial court said, based on the preponderance of the evidence, I find it's not knowing, intelligently, and voluntarily established. So I understand that how you described his order could arguably say, hey, he looks like he applied the correct standard here. But let's go over the pieces of evidence. Your expert used a different form.
Yes, Your Honor, with respect to a few certain vocabulary words.
Well, consult with your attorney versus seek the advice of your attorney. Consult is a fairly sophisticated word. Interrogate versus question. So your expert did not take the form used by the law enforcement officers and say, look, looking at this form here, I find ABC.
That is true, Your Honor, but it wasn't just a comparison of Miranda rights that was used by Dr. Derrico to evaluate Jason Beck's competence. Also, the IQ's test was given, and also a vocabulary words test was given. And also there's case law speaking directly to the issue, which I think you're getting at, and Benitez. The expert in that case also used a different and more sophisticated form than the tester, and yet the court accepted those findings. Now, the court was, of course, overturned on the different grounds, but I think it speaks to the issue of the different forms. Also, Jason Beck was unable to understand the word right, which, of course, is a fundamental component in the core of the Miranda issue. And at the suppression hearing, actually, it was mentioned by the state that Jason Beck was able to use the word right in a sentence back to the doctor. But that sentence that he said was, when he was asked to explain or interpret, you have the right to remain silent, he responded, you have the right to remain silent, or you better not just shut up. He clearly did not understand, and I think I just wanted to point that out to the court, that that's an example of how we're really not seeing with these little bits and pieces of contextual and taken out of context evidence that Mr. Beck did not fully understand.
What about the evidence from the actual interrogation back to the state's back to the non-expert witness testimony? he signed a Miranda form, right?
He did, Your Honor. He was reportedly read the top portion of the form. The actual form he used was not on the record of appeal, so I have no way of, and it was not specified in the suppression hearing whether or not each individual right was read to him slowly, whether there was the eye contact made, which the court discusses.
Don't you agree a fair reading of the record shows the police saying, hey, we want to make sure you understand here? I mean, they stop once or twice and clarify with him, right?
Not at all, Your Honor. I would say that that is the police reacting to
Well, why don't you describe that?
Okay.
That interplay.
The police come in. They have requested my client to come into the interrogation room, and they refer to having previously, off the record, read the top portion of the Miranda form and then giving my client an opportunity to read the bottom part of it. We're not sure what that contains, okay? Subsequently, they begin asking him about the incident, and they back up and they say, with reference, Mr. Beck, to your previous request to see your wife, or maybe that you had indicated you needed someone to help you understand because we were talking too fast, and my client responds, yeah, because I didn't understand every word or law, essentially. And they say, we told you, isn't it true, that you could either continue to talk to us or we can walk out that door. Or do you want to continue to talk to us, or do you want us to walk out that door, was what was said. And my client responds, talk. Now, our expert explains that in terms of saying that Mr. Beck was merely cooperating, and the state was certainly free to rebut that assertion at the hearing. They didn't.
Isn't that the point? Go ahead, Judge.
Oh, I mean, doesn't the record reject the expert's conclusion by him saying talk?
Not at all, not necessarily, Your Honor, because the Ramirez factors,
But Ramirez is the juvenile case, right?
I would disagree with that, Your Honor.
That's the juvenile that confessed in the murder.
It is a juvenile that confesses, but even the concurrence in Ramirez indicates that even if the case had been adjudicated without a juvenile, if it had been an adult present, the case would have come out the same. This is a totality of circumstances standard. I would suggest that Ramirez is a totality of circumstances standard with an emphasis on the juvenile status. And my case with my client is a similar totality of circumstances analysis with a focus on a mentally deficient client. Your Honors, I would just like to say, I see my time is growing short, that all that we've been talking about for the past 14 and a half minutes truly is the nuts and bolts of an inquiry that you only reach if you bypass the trial court's discretion. This court, the Supreme Court, have on many occasions said that all interpretations of the evidence as well as inferences and deductions of fact should be interpreted in the light most favorable to sustaining the court's ruling. Even this court came out with another ruling this past Friday in Faudree v. State, which reiterated that very sentiment, and I would ask you to affirm on those grounds. Thank you very much.
Thank you, counsel.
Good morning, and may it please the court. My name is Angela Hensel. I'm a certified legal intern representing the state. I would just like to start with answering the question that you asked earlier of both counsel. There has to be some kind of evidentiary support in the record to support the trial court's ruling. And if there wasn't, no trial court would ever be able to be appealed without some kind of evidentiary finding. And in this case, there was no facts finding found to give deference to. However, there was support in the record to show that there was no competent substantial evidence to show that this client.
You don't think the expert witness saying I can see, quite frankly, if he hadn't used the word probable, I can see the argument that, hey, all this expert said was it's possible that he didn't understand these warnings. But then he clarifies and says it's probable in this case. And then he goes on to say people in this intelligence range want to appear normal. They want to cooperate. You don't think that's enough to sustain the trial court's ruling?
Well, Your Honor, if you look at page 123 and 124 of the record, Dr. D'Erico could not say that this defendant was in fact mentally retarded. And on page 136, he could not definitively say that this defendant was in fact making involuntary statements. And then
Dr. D'Errico goes on to say that he could not definitively say that this defendant was actually acting to accommodate the police officers by making the statements to appear normal because of his IQ of 70. Therefore, we're just left with the fact that the defendant has an IQ of 70. There was absolutely no police coercion, and we learned in Colorado v. Connolly that in order for statements to be involuntary, there has to be some sort of police coercion driving them to make those statements, and that just wasn't the case here. Additionally, looking at the totality of the circumstances in this case, this defendant is over the age of 30, who has had 2 prior run-ins with the judicial system where he was made 2 guilty pleas.
Those were misdemeanors, though.
It's
a far cry from being brought in and interrogated on second or first-degree felonies, right?
Yes, but Your Honor, he did validly waive his constitutional rights when he entered those guilty pleas, and 2 judges found that he was competent enough to make those pleas in order to waive his rights. And he gave a valid waiver. And if you
Does the state make that argument below? Judge, by the way, he was found competent to enter those misdemeanor pleas?
I do not believe so. Additionally, in the record it says that he was advised of his Miranda rights, and then he was read the top portion, and then he read the bottom portion to himself. So he validly waived when he signed that waiver form. And I see that my time is coming to an end. Therefore, we would respectfully request that this court reverse the trial court because their finding was legally incorrect and not supported by any competent substantial evidence. Thank you.
Thank you, counsel. I would point out that I believe that these oral arguments are recorded and they are available on the court's website. I'm not sure when that will happen. And you might even be able to get a copy on disc if you want to contact the clerk's office. Thank you.